This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about res judicata, why a party only gets one bite of a defendant and only once. And a condo associations seem to be birthplaces of litigation. Plaintiff Nationwide Mutual brought a declaratory judgment action against its insureds, Beverly Glen Homeowners Association, and members of the board of directors, asking the court to declare that Nationwide had no duty to defend or indemnify the defendants against claims made by the association's residents in a derivative suit. The trial court granted Nationwide's motion for judgment on the pleadings, finding that res judicata and collateral estoppel barred the defendants from seeking a defense in the derivative suit where judgment rendered in a prior case determined that Nationwide had no duty to defend. In Nationwide Mutual versus Beverly Glen, a July 7, 2023 decision of the Court of Appeals of Illinois, the court was asked to resolve the dispute. It found that the lawsuit arose out of an ongoing dispute between defendants and Teresa and Katarzyna Jagiello, two association residents. On April 14, 2022, the trial court granted Nationwide's motion. It held, quote, "There is no material issues of fact in dispute. It is clear as a matter of law that the lack of cooperation on the part of the insured and its counsel has relieved Nationwide of its duties under the policy. Nationwide's insureds failed to cooperate with Nationwide, relieving Nationwide of its duties under the policy, and Nationwide owes nothing to the insured for any legal services. As such, Nationwide owes neither a duty to defend nor indemnify its insured," close quote. The doctrine of res judicata serves to bar actions which, 1. There was a final judgment on the merits rendered by a court of competent jurisdiction, 2. There is an identity of the cause of action, and 3. There is an identity of the parties or the privies in both actions. Res judicata prevents the relitigation of issues that could have been decided in the first action, along with those issues that were actually decided. When the directors of a condominium association, as the arms of the association, and for all intents and purposes are one and the same. In other words, there exists a legal relationship in which the directors, acting within the corporate authority, bind the association. When a valid and final judgment rendered in an action extinguishes the plaintiff's claim, the claim extinguishes and includes all rights of the plaintiff to remedies against the defendant with respect to all or any part of the transaction or series of connected transactions out of which the action arose. Res judicata is an equitable doctrine that should be applied only as fairness and justice require. It is intended to be used as a shield, not a sword. Nationwide is asserting the doctrine in a declaratory judgment action to obtain a no duty to defend ruling. It is contrary to defendant's argument, attempting to use the doctrine as a shield in the underlying derivative suit. Under the circumstances, applying the doctrine to deny defendants coverage in the derivative suit would not be unfair or unjust. Defendants have refused to produce documents, ignored settlement agreements, and court orders require them to do so, and failed to cooperate with Nationwide's counsel in defending their actions. In continuing to dispute, it should come as no surprise to the defendants that Nationwide would have no duty to defend or indemnify their actions. The trial court did not err in granting the motion for declaratory judgment on the pleadings in the insurer's favor based on the doctrines of res judicata and collateral estoppel, where The order entered in the prior case, finding that the insurer had no duty to defend or indemnify the insured, involved identical causes of action, and parties were in privity with the parties in the underlying dispute, because regardless of the directors of the association, the party is the association, an entity called a condominium corporation. In my opinion, the basic covenant of good faith and fair dealing requires that neither party to the policy may do anything to deprive the other of the benefits of the policy. When the condo association failed or refused to cooperate in the investigation of a claim and to cooperate in the defense of that claim, a court found that the insurer owed neither defense nor indemnity to the association because of its breach of the contract by the association. When a new set of directors sought defense of the continuation or a different set of arguments by the same parties seeking the same remedies of the same dispute, res judicata applied because the association was the entity involved, regardless of who was sitting on the board of directors. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and you will receive notice of every blog posting, usually 5 a week, and access to the more than 4,550 posts on the blog. You can also subscribe to the videos on YouTube and rumble.com, and if you do, I'd appreciate it if you click on the like button or the thumbs up button on Rumble. And if you found these videos and the blog to be of use, please tell your friends and colleagues so that they can also subscribe. And if you wish to go into further detail on insurance coverage, and insurance law and insurance fraud and insurance claims, it might be worthwhile to you to consider subscribing for a very small fee to my locals community or my Substack publication. Thank you for your attention.